from Group 2. Today we're going to present our presentation video from our assignment Law, which is question 8. I hope you enjoy.
My name is Nik Almardia Ibadi binti Muhammad Hamran. There are three main issues in this case, which the first one is whether there is a breach of implied condition as to fitness for particular purpose between Zalina and the seller. Next issue is whether Zalina has the right to claim under the Sale of Goods Act 1957, and the last issue is whether Zalina depended on the seller's skill or judgment in recommending the laptop.
In this slide, I'll be talking about an important Malaysian law called the Sale of Goods Act 1957. This law governs how goods are bought and sold in Malaysia. It aims to make sure all transactions are fair, transparent, and legally secure for both buyers and sellers. The Sale of Goods Act mainly applies to movable items, things that can be physically moved, like laptops, phones, or even second-hand items. It explains the rights and duties of both the sellers and buyers and ensures that both parties are treated fairly. The Act also makes a clear contract for the sale of goods are treated like any other contract. So legal concepts such as offer, acceptance, consideration, and capacity to contract still apply. One important point is that the Sale of Goods Act covers all types of sales, including first, new and second-hand goods, second, retail and wholesale, third, and lastly, commercial and private sales. So whether you are buying from a store or from a friend, the same rules can apply. According to Section 3 of the Sale of Goods Act, the Contract Act 1950 still applies to sales contracts as long as there is no conflict between two contracts. This means both acts can work hand in hand to protect both sides of transaction. Section 4.1 of the Act tells us what a contract sales means. It's a contract where the seller agrees to transfer property or ownership of goods to the buyers for a price. It's not just about handing over the goods, it's about transferring ownership in exchange for payment. Let's talk about the difference between sale and agreement to sell, based on Section 4, Subsection 3 and 4, Subsection 4. A sale is when the ownership of the goods transfers immediately from seller to buyer. An agreement to sell is when the transfer of ownership will happen later, either at a future date or once certain conditions are met. For example, if you pay a deposit for a car and agree to pay the balance next month, there is an agreement to sell. Once full payment is made, it becomes a sale. To conclude, the Sale of Goods Act 1957 is essential for protecting buyers and sellers in Malaysia. It defines what a sale is, explains the responsibility of both parties, and ensures that contracts are legally valid and fair. By understanding this act, we can make more informed decisions when entering into any transaction involving goods. Continuing from our earlier discussion on the Sale of Goods Act 1957, let's now take a look at more specific section of the Act that further define what goods are, the type of goods, and the different types of term in a contract. According to Section 2, goods refers to every kind of movable property except for actionable claims and money. This includes things like stocks and shares, growing crops and grass, even items attached to land as long as they are agreed to be removed before the sale. This means the definition of goods is very broad and includes both tangible and some intangible items. Under Section 6, Subsection 1, there are two types of goods in a contract of sales. First, existing goods, goods that are owned or possessed by the sellers at the time of the contract. 2. Future goods, goods that will be manufactured, acquired, or proceed later. For examples, selling a car you currently own is an existing good, but agreeing to sell a car that you will import next month is a future good. Now let's look at the term of a contract. They are traditionally divided into two conditions and warranties. A condition is a core term essential to the main purpose of the contract. If a condition is breached, the buyers can terminate the contract. This is under Section 12, subsection 2. A warranty is a minor term, one that is not central to the contract. If a warranty is breached, the buyer can claim damages but cannot cancel the sale. This is found in Section 12, subsection 3. Section 13, subsection 1 gives buyers the option to treat a breach of condition as just a breach of warranty, meaning they can choose to continue the contract and only claim damages. Under Section 13, subsection 2, in certain cases, the law automatically treats the breach of condition as a breach of warranty, such as if the contract is not severable, meaning it must be completed as a whole, and the buyer has accepted the goods or part of them, or if the sale is for specific goods and ownership has already transferred to the buyer. Lastly, Section 11 of the Act deals with implied terms about time. It states that time of payment is not usually essential unless the contract says so. So, if someone pays a bit late, that doesn't automatically give the sellers the right to cancel, unless time is clearly made a crucial part of the agreement. To sum up, these sections of the Sale of Goods Act give us a deeper understanding of what counts as goods, how sales are classified, and how terms like conditions and warranties affect the right of buyers and sellers. Understanding these key legal concepts helps us avoid and make contracts clearer and more reliable for everyone involved.
The next section is Section 13, subsection 1 of the Sale of Goods Act that permits the buyer to treat a breach of condition as a breach of warranty. Section 13, subsection 2 provides the breach of condition must be treated a breach of warranty, which is where the contract is not severable and the buyer has accepted the goods or part thereof, or where it is for specific goods, the property has passed to the buyer. Furthermore, implied terms as to time under Section 11 of the Sale of Goods Act mention that unless a different intention appears from the terms of the contract, stipulations as to time of payment are not deemed to be of the essence of a contract of sale.
So hi everyone, my name is Nur Adina Ilani binti Abu Bakar, and today I briefly walk you through a key implied terms under Section 14 of the Sale of Goods Act, which safeguard buyers in a contract for the sale of goods. So firstly, under Section 14A, unless the contract states otherwise, there's an implied condition that the seller has the right to sell the goods. In a sale, the seller must have the legal title at the time of sale. So, in an agreement to sell, they must acquire the title before ownership passes. For example, if a seller doesn't initially own the goods but acquire title later, they can still enforce the sale provided the buyer hasn't already repudiated it. So next, in Section 14B provides an implied warranty of quiet possessions. This ensures that the buyer can enjoy the goods without wrongful interference, not only from third parties but also from the seller. For instance, if a seller tries to repose goods due to unpaid dues, this would violate the buyer's right to quiet possessions. Lastly, Section 14.3 states that the goods must be free from undisclosed charge or encumbrance, such as an liens or mortgage. If an hidden charge exists and was not disclosed, the buyer can claim damages or take legal actions. To conclude, Section 14 of the Sale of Goods Act protects buyers by ensuring rightful ownership, peaceful enjoyment, and freedom from hidden burdens, unless the party have agreed otherwise. Section 15 of the Sale of Goods Act, which deals with contract for the sale of goods by descriptions. So Section 15 states that in a sale by descriptions, there is an implied condition that the goods must correspond exactly with the description provided. So this means even if the goods are only slightly different, the buyer has the right to reject them. So this is a strict obligation even if the defect is hidden or not easily detectable. The seller is still liable if the goods don't match the descriptions. So for example, if a buyer orders a stainless steel kettle and receives an aluminium one instead, even if it looks similar, the buyer can reject it. So Section 15 applies in two main scenarios. So when goods are uncertain at the time of contract, when the buyer hasn't inspected the goods, like in email order, catalog sales, or online purchase, the main purpose of this section is to protect the buyer, making sure they receive exactly what was described in the agreement. So it ensures fairness, especially when the buyer relies solely on the seller's descriptions. So, to conclude, Section 15 ensures that buyers are misled if the goods don't match the description even slightly. It's a breach of a contract. Next is Section 17(1) of the Sale of Goods Act, which applies to sale by sample, often used in bulk purchase. The basic idea is that the sample speaks for itself. The buyer agrees to purchase goods in bulk based on a small sample shown by the seller. Under Section 17(2), three key implied conditions must be met. First, Section 17(2)(a), the bulk must correspond in quality with the sample. Section 17(2)(b), the buyer must have reasonable opportunity to compare the bulk with the sample. Section 17(2)(c), the goods must be free from any hidden defect that make them unmerchantable, which would not be noticeable during a reasonable inspection of the sample. Under Section 17(2)(c), even if the buyer inspects the sample carefully, the seller is still liable for latent defects, those that an ordinary buyer could not detect. For example, if a food product contains contamination not visible in the sample, the buyer can reject the entire batch. These three conditions are independent of one another. A breach of any one gives the buyer the right to reject the goods and treat the contract as terminated. To summarize, Section 17 protects buyers in bulk sales by ensuring the sample reflects the entire shipment. If the goods don't match in inspections isn't allowed, or if there are hidden defects, the buyer has the right to walk away from the deal.
Assalamualaikum and hi everyone. My name is Wan Nur Aina Fauzana binti Wan Azman. So, for the first one is disclosure of purpose to the buyer. Under the Sale of Goods Act 1957, if a buyer tells the seller the specific purpose of the goods and relies on the seller's skill or judgment, the goods must be reasonably fit for that purpose. When the buyer does not disclose their special needs, the seller is only expected to provide goods suitable for ordinary or general use. This is known as disclosure of purpose rule, and it protects buyers only if the intended use is communicated clearly at the time of purchase. The example case for this element is Griffith versus Peter Conway Limited 1939. So in this case, Miss Griffith bought a coat from the seller without mentioning her skin. She later suffered a reaction and claimed the coat was unfit for use. The court rejected her claim, ruling the coat was fit for normal use because she did not inform the seller of her special condition. The seller was not liable. So in this case, shows that if a buyer has special requirements, they must inform the seller. Otherwise, they cannot claim under the fitness for purpose rule.
The next requirements that Zalina has to fulfill is she needs to establish reliance on the seller's skill and judgment. Under the Sale of Goods Act 1957, if a buyer tells the seller what they need the goods for and relies on the seller's expertise, the goods must be suitable for that purpose. The existence of reliance is when the buyer depends on the seller's knowledge instead of choosing the product themselves. Reliance can be shown by direct communication or by the nature of the transaction. For example, when a buyer consults a seller about professional product selection. However, this rule does not apply if the buyer chooses a product just by brand or pattern without relying on the seller. Furthermore, there are 4 example cases that related to this case. First is Grant vs. Australian Knitting Mills 1936. Second is Gillespie Bros vs. Cheney Eager and Company 1896. Third is Manchester Liners Limited vs. Re-Limited 1922. And lastly is Camel Laird and Company vs. Manganese Bronze and Brass Company Limited 1934. So, one of the example cases are Grant vs. Australian Knitting Mills 1936. In this case, the plaintiff purchased underwear from Australian Knitting Mills. Then, he developed dermatitis from wearing the underwear because of excessive manufacturing chemicals. The court decided that buying from a retailer implies a buyer relies on the seller's judgment when expecting suitable products. And the court determined that the buyer depended on the seller's selection, expertise, and the seller became responsible because the products failed to serve their intended purpose.
Another important legal concept under the Sale of Goods Act 1957, specifically about the sale description and fitness for a particular purpose, supported by the case Ashington Figures Ltd versus Christopher Hill Ltd 1972. When goods are sold by description, there is an implied condition that the good must match the description given. The good must be fit for the particular purpose made known to the seller. Also, the description must relate to goods that the seller ordinarily supplies in the course of their business, even if they don't sell the exact brand or type. Let's look at the case Ashington Figures Ltd contracted Christopher Hill Ltd to supply mink feed using a specific formula. Christopher Hill used hearing meals from a third-party supplier. Unfortunately, it was contaminated and toxic to minks. As a result, many animals died. Although Christopher Hill has experience in animal feed generally, they had not sold mink feed before. The House of Lords held that the feed did not match the description and was not fit for the known purpose. The seller, Christopher Hill, was liable, even though the contamination came from a third party and they had not sold mink feed before. This case shows that when a seller is in the business of supplying a general type of goods, they are still responsible if the goods fail to meet the requirement standard for a known use. The main lesson from this case is a seller cannot escape liability by saying they haven't supplied a specific brand or variant before. If the goods fall under the general description of what they usually sell, they are expected to ensure the goods are exactly as described, safe, fit for the purpose made known by the buyer. Even if the problem is about quality rather than identity, the seller is still legally responsible. Explain what merchantable quality means under Section 16, Subsection 1, Subsection B of the Sale of Goods Act 1957. When you buy something by the description, like online or from catalog, the law says the item must be merchantable quality. This means the product must be good enough for normal use. It should work properly, it should not have serious defects, it should last reasonable time based on the price and type of product. The rule applies when the seller usually sells the kind of product even if they are not manufactured. But if the buyer examines the product and the problem is something they should have seen, then the seller is not responsible for the defect. So if the damage is so obvious, you can't complain later. For example, if you buy a laptop, it should turn on, the screen should be clear, it should run normally, but if you saw a crack on the screen before buying it, you can't later say it wasn't in good condition. In short, merchantable quality means the product must be safe, usable, and worth the money unless the buyer already saw the problem.
Next, a key exception to the implied condition of fitness for purpose under the Sale of Goods Act 1957, specifically when goods are purchased under a patent or trade name. Under Section 16(1)(a) of the SGE, when a buyer makes known the particular purpose for which goods are required and realized on the seller's skill or judgment, there is an implied condition that the goods will be fit for that purpose. However, this condition does not apply when the buyer orders specific goods by their patent or trade name. In such case, the law assumes the buyer is not relying on the seller's skill, but rather on the reputations or specification of the product itself. In Baldry v. Marshall, 1925, the buyer requests a Bugatti car for touring purpose. The car turned out to be unsuitable, but the court held that since the buyer had specified the car by trade name, nor implied condition of fitness apply, so the buyer could not claim a breach. So, the takeaway: if a buyer chooses goods by brand or model name, they take responsibility for their sustainability. So this rule protects sellers when buyers make an informed brand-specific choice without relying on expert advice. To conclude, when buying a patent or trade name, there's no implied guarantee of fitness for purpose. Buyers must be continuous. They are on their own in judging sustainability.
I will explain an important part of the Sale of Goods Act 1957, which is Section 16, focusing on the fitness and quality of goods in a sale. This section is about when a buyer can expect goods to be suitable for a particular purpose, even when it's not clearly stated in the contract. Section 16, Section 1 begins with a general rule. There is no implied warranty or condition that the goods will be of a good quality or fit for a particular use. These rules follow the legal principle of caveat emptor, which means let the buyer beware. In simple terms, buyers must take responsibility for checking the goods themselves before buying. However, Section 16, Subsection 1 also includes exceptions where an implied conditions will apply. There are two important exceptions. First, Section 16, Subsection 1, Subsection A, fitness for a particular purpose. Second, Section 16, Subsection 1, Subsection B, merchantable quality. These exceptions protect the buyers in specific situations where it's reasonable to expect the goods to meet certain standards. Section 16, Subsection 1, Subsection A says there can be an implied conditions that goods are fit for a particular purpose if four requirements are met. The buyers makes known to the sellers the particular purpose for which the goods are required. Second, the buyers relies on the seller's skill or judgment. Third, the goods are of a type normally supplied in the course of the seller's business. The goods are sold under a contract of sale. If these four elements are present, the law assumes that the goods must be reasonable fit for the specific use. Under Section 16, Subsection 1, Subsection B, if the buyer buys goods by description from a seller who deals in those goods, there is an implied condition that the goods are of merchantable quality. This means the goods should be usable, safe, and free from major defects, making them suitable for sales in the market. To summarize, while the default rule in Section 16, Subsection 1 is that buyers are responsible for their own checks, there are important exceptions under Section 16, Subsection 1, Subsection A and 16, Subsection 1, Subsection B that protect buyers in fair and reasonable situations. This helps to balance the interests of both the buyers and sellers, especially when the buyers relies on the seller's expertise.
Moving forward for the application, as for this case, it falls under exceptions to Section 16A of the Sale of Goods Act 1957, which is there will be an implied condition that goods are reasonably fit for a particular purpose. This is because Zalina has told the seller that she needed a laptop for video editing and for a long hour of use. Then she relied on the seller's recommendation, so the seller is expected to supply a laptop fit for that purpose. So there is a breach of implied condition because Zalina clearly told the seller that she needed a laptop that could handle video editing and be used for long hours. And the seller recommended the ProGraph X 5000 laptop based on what Zalina said, which meant the laptop was supposed to be suitable for that use, but the laptop keep crashing and can't handle the heavy processing needed for video editing, showing that it's not really fit for the purpose Zalina explained. In addition, since Zalina has explained what she needed and relied on the seller's recommendation, she has the right to say the laptop is not fit for what she wanted it for. The seller's refusal to provide a refund based on the argument that the laptop was bought by trade name is not a valid defense if Zalina can prove reliance on the seller's skill and judgment. Hence, Zalina has the right to take legal action about this case. Last but not least, Zalina trusted the seller's recommendation when she decided to buy the ProGraph X 5000 laptop. She believed the seller knew what they were talking about and would suggest a laptop that fit her specific needs. So this kind of trust in the seller's expertise is important under the Sale of Goods Act because it helps prove that the laptop was supposed to be suitable for the purpose she told them about. As a result, Zalina has the right to take legal action against the seller to terminate the contract and claim her rights, such as refusing to accept the laptop and claim a refund or damages from the seller.
In conclusion, Zalina has fulfilled all the requirements and she can take the legal action under Section 16, Subsection 1, Paragraph A of the Sale of Goods Act 1957. Thus, she has the right to claim a refund or reject the laptop.